We appreciate that this Honorable Court of its own volition has granted leave to appeal. Speaking for myself, obviously the decision is that of the client. So I will be advising the client, but it is for the client to make the final decision. But in fairness to me as counsel and other counsel on this bench, I will certainly be seeking to persuade my client to appeal. One issue of accusing counsel to have been talking to the gallery, that is not something that should be left on the record of this court. It is damaging to counsel, and that is an issue that definitely needs to be taken out of the record of this court by the Court of Appeal. It was a very unfair accusation. Thank you.
Yes, Counsel.
My Lords, Your Ladyship, on Friday, when the court gave directions on how to proceed today, as my Lord the presiding judge observed, perhaps all of us had been working very hard the previous day. So the court left rather quickly when I was on my feet. And I was standing up to draw this Honorable Court's attention to the fact that no directions had been issued in respect of an application which is on record, which is a contempt application in the Kirugoya matter, where the judge, your brother, in the Kirugoya matter, directed that because of the urgency of the matter and that he had referred the file to the Chief Justice, that application for contempt, which was on record, would be argued before the bench to be constituted by the Chief Justice. So that application continues to be on record, and I would need that you give directions on its hearing and disposal. Because as we all know, a contempt ordinarily is not permitted audience before purging the contempt. Can we have your directions for that contempt application to be heard and determined?
Why are we being discriminated by the court that our files are not considered as a priority, and that the files with orders are the only ones that the court is sitting on a Saturday? The Chief Justice is impaneling, the Deputy Chief Justice is impaneling the bench. We are called, like in a lightning speed, to appear before you. Is it not because there are some orders that the state wants to vacate? You cannot run away from that reality, Your Lordship, most respectfully.
My Lord, with your kind permission.
As a matter of fact, the High Court looked at the evidence before it relating to public participation in the process now before you. The Court of Appeal, as a court of first appeal, had an obligation, and it re-evaluated the material that was before the High Court and came to its own conclusion, and the conclusion was insufficiency of public participation as a matter of fact. I submit respectfully that it is not open for counsel appearing before you or for this court in its decision-making process to reopen that factual issue as to whether there was, in fact, sufficient public participation. As a matter of fact, the High Court, as a court of first instance, and the Court of Appeal exercising that jurisdiction I've alluded to, re-evaluated the question of who initiated this process. And it came to the conclusion that it was the President of the Republic of Kenya who initiated this process.